dwarf goblins. I mean, she literally looks like a goblin, I'm just telling you, and acts like a goblin.
Just because you claim to think something is true does not make it true.
The jury awards almost $50 million in damages against Alex Jones and his companies for defaming the parents of children killed in the Sandy Hook massacre. After years of being targeted by Alex Jones, the parents finally had their chance to address Jones to his face in court, and things did not go well for Jones. Just how bad was it? So bad that former prosecutor Mitchell Epner said, "In over 25 years as a trial lawyer, I have never seen a witness do more damage to himself on the stand than Alex Jones, and that includes a case where I was AUSA, where I got a defendant to admit that he was guilty of the crime charged in the indictment." It was so bad that also former prosecutor Ken White said, "It was like an action movie where it's not enough that the bad guy gets shot or stabbed at the end, he's gotta be like decapitated and exploded and impaled at the same time." But let's start at the beginning. Why was Alex Jones on trial? In 2012, a lone gunman murdered 6 adults and 20 children at the Sandy Hook Elementary School in Newtown, Connecticut. Alex Jones and his associate Alan Schroyer and Wolfgang Helbig said that the event was a hoax that did not happen.
The whole thing is a giant hoax.
The Jones gang accused the bereaved family members of being, quote, crisis actors.
And it just shows how bold they are, that they clearly used actors.
And Jones and his correspondents repeated those claims on InfoWars broadcast.
Okay, so just another question that people are now going to be asking about Sandy Hook.
Alex Jones's fans harassed the parents online and at their homes. And after several years of this, some of the Sandy Hook families sued Jones for defamation in Connecticut and Texas. During his deposition in one of the other Sandy Hook cases, lawyers played clips of Jones mocking the parents and calling their tears bad acting.
The only problem is I've watched a lot of soap operas, and I've seen actors before. And I know when I'm watching a movie, I know when I'm watching something real.
And in response to those clips, Jones admitted under oath that he knew his statements were false. After his deposition, Jones and InfoWars denied having emails, text messages, and other material about the Sandy Hook claims. Jones and his lawyers then ignored court orders to produce documents in Texas and Connecticut. And spoiler alert, during the damages trial, we found out that they lied about having this material when one of his lawyers accidentally sent Jones's entire cell phone and a whole bunch of other documents to opposing counsel.
Your attorney's messed up and sent me an entire digital copy of your entire cell phone with every text message you've sent for the past 2 years.
And Jones has a whole pattern of disregarding discovery obligations in other cases as well. And some people have claimed that Jones has gotten railroaded by having liability conceded by default, and that Jones's constitutional rights have been infringed. That is not the case here. It was a strategic choice by Jones and his attorney to not turn documents over, all the while claiming that they never possessed relevant documents and that those documents didn't exist. We know now that that is not the case, that it was a strategic choice to hold those documents back, never turn them over, and then face the repercussions in court, which is what they basically have done, and why liability was conceded.
But I'm not going to seal the entire quantity of information without knowing what's in it when the rules weren't followed properly.
And taking all of that into consideration, the judges in all 10 Sandy Hook cases entered default judgments against Jones and his companies. A default judgment happens when the defendant in a civil case fails to do something such as ignoring court summons, missing a court date, or disregarding the judge's direct orders. And if this occurs, a court may rule in favor of the plaintiff by default. And this is very rare. A default judgment is the most serious sanction a judge can impose during a civil trial. Judges do not enter default judgments very often. But if you want to learn more about why the default judgments were entered against Jones, check out my video on the topic. I have an entire video on the pre-damages portion of this trial. But this particular case that we're talking about today is the first of 3 upcoming trials that will decide how much money Jones and his companies must pay in damages. It was filed by Neil Heslin and Scarlett Lewis, who are the parents of 6-year-old Jesse Lewis, who was killed at Sandy Hook. And since the default judgments were issued, Jones couldn't contest liability. The trial was only about how much Jones must pay, and the plaintiff sought $150 million in compensatory and punitive damages. So what did the plaintiff say during trial? Well, Neil Heslin was the first plaintiff to testify.
I can't even describe the last 9.5 years of the living hell that I and others have had to endure because of the negligence and the recklessness of Alex Jones.
He and Lewis said that strangers have confronted them everywhere, including at their homes. Heslin's house and car have been shot by people yelling out Alex Jones.
Somebody drove by my home shouting out the window, Alex Jones, and it sounded like gunfire coming from the vehicle.
Heslin gave heart-wrenching testimony about holding his son and seeing that he had a bullet hole through his head. Owen Troyer went on Jones's program and said that Heslin lied about holding his son's body.
I think it's time for you to explain this contradiction in the narrative.
And this is apparently what prompted Heslin and Lewis to fight back.
Alex started this fight, and I'll finish this fight.
Now, Jones wasn't in court to hear Heslin's testimony about Jesse. It's not necessary to show up to court, but usually you do want to do that. Instead, while Heslin testified, Jones did a live show where he called Heslin slow and autistic and accused him of being manipulated by lawyers.
But I'll just say, because I gotta be honest, he's slow, okay?
This was not a good strategy because this clip was then played in court for the jury just a few days later.
I mean, I think Heslin acts like somebody on the spectrum.
It supported one of the plaintiff's key claims that Jones has spent years ridiculing the Sandy Hook parents and that he can't control himself or his employees who continue to harass the families. Now, after court, Heslin and Jones had a confrontation where Jones again called Heslin a slow person who's being manipulated by lawyers. Jones also ripped the judge on his InfoWars program.
And they're all caricatures of what you would imagine in some alternate universe of dwarf goblins. It's demonic. They all act demonically possessed. The judge, the lawyers.
Now, part of our job as lawyers is client control. We tell our clients not to talk about their cases in public. Don't post to Facebook. Don't share things in the media. Don't talk with friends and family. But ultimately, though, it's up to the client to demonstrate some self-control.
Judge Goblin here in Austin, I mean, she literally looks like a goblin, I'm just telling you, and acts like a goblin.
Even the greatest lawyers in history would probably be powerless to stop Jones from, being himself. And then there was the testimony of plaintiff Scarlett Lewis. Jones was again not in court for the first half of Scarlett Lewis's testimony. When he finally arrived, he was accompanied by a team of bodyguards. Lewis addressed her testimony directly to Jones while he sat at the defense table.
I am a mother, first and foremost, and I know that you're a father. And my son existed. I know you believe me. And yet you're gonna leave this courthouse and you're gonna say it again on your show.
At one point, Lewis directly asked Jones,
You think I'm an actress?
No, I don't think you're an
No, you can't talk right now.
Sorry.
Now, Lewis told Jones that he makes claims about the massacre that he knows are lies.
But when you say those things, there's a fringe of society that believe you, that are actually dangerous.
And Lewis emphasized the deep trauma that she has because of Jones and his followers.
It seems so incredible to me that we have to do this. That we have to implore you, not just implore you, punish you, to get you to stop lying.
A forensic psychologist who met Heslin and Lewis said both suffer from a form of post-traumatic stress disorder that comes from constant trauma. Jones's lawyer, Reynald, had a tough time handling these witnesses on cross-examination because it would be incredibly hard to cross-examine these witnesses. At one point, he suggested that it would be more healing for Lewis and Heslin to sit down and talk through their trauma with Alex Jones than it would to file a lawsuit. On cross-examination, Jones's lawyer grilled Lewis about her finances, noting her book contract and speaking engagements.
Can you tell the members of the jury how much is this suggested honorarium for your speaking engagement?
It may be $5,000.
Would 10 be more accurate?
It could be 10.
And he said that she makes more than enough to pay for her own therapy. Now, I'm going to go out on a limb here and say that this questioning probably did not go over particularly well with the jury. And then there's this testimony of Alex Jones himself. When he took the stand, he told plaintiffs that he's always wanted to apologize.
That I never intentionally tried to hurt you. I never even said your name until this case came to court. I didn't even really know who you were until a couple years ago when all this started up. The internet had a lot of questions. I had questions.
Jones argued that he made a few inquiries about whether Sandy Hook was a false flag operation, and then the mainstream media reported on what he said and turned everything into a circus. The media, Jones said, created an atmosphere where nobody knew what the facts were, so there was no real way for him to get it right. Jones and his lawyer argued that the Sandy Hook parents were victimized 4 times by the shooter, by truthers, by politicians, and by everyone else who took their grief and weaponized it. In other words, it wasn't his fault. Now, on cross-examination, Jones also admitted that he had basically called every major event of the last decade a false flag incident engineered by the government. Now, the judge was not pleased by any of this. You've probably seen the incendiary clips of the judge telling Jones to stop lying under oath.
You're already under oath to tell the truth. You've already violated that oath twice today.
Now, the judge admonished Jones for a number of different things. The first was telling the jury that he was bankrupt. Jones repeatedly testified that he only makes money selling prepackaged prepper food for like an apocalypse. Everything else was money losing, he claimed. But plaintiffs had already shown that InfoWars was making a lot of money, as much as $800,000 a day during certain events. And one of his employees testified that the company makes about $50 million annually.
That's what the document says.
Though faced with 3 upcoming trials, Jones and his companies have started bankruptcy proceedings. Now, when a company files for Chapter 11 protection, it tends to stay the other legal proceedings. Jones has many LLCs, but the biggest company is Free Speech Systems. Free Speech Systems filed for bankruptcy in Texas, so Jones's lawyer moved to stay the Connecticut proceedings, which is a different case. But this was the second delay in the Connecticut case because of bankruptcy maneuvers. Back in April, InfoWars and 2 of its subsidiaries, InfoWars Health LLC and Prison Planet LLC, also filed for bankruptcy protection. Now, these entities were removed as named defendants so that the damages proceeding could move forward. Now, Free Speech Systems listed $14.3 million in assets, including over $1 million in cash and almost $1.6 million in property and equipment. However, the petition claimed the company had $79 million in liabilities, including a $54 million debt owed to something called PQPR Holdings. Now, who owns PQPR Holdings? Well, it's Carol Jones and David Jones, also known as Alex Jones's mom and dad. Now, the Sandy Hook plaintiffs believe the bankruptcy proceedings are a sham. Heslin, Posner, and 2 other Sandy Hook families filed separate lawsuits accusing Jones of hiding millions of dollars in assets. The plaintiff said the $54 million debt was dubious since PQPR is a Nevada-registered company that is owned by shell entities owned by Jones's kids and parents. There's substantial evidence of fraudulent transfers, and it's not even clear that the bankruptcy court would discharge the Sandy Hook judgments anyway. So while Jones may delay, it's likely to be a Pyrrhic victory. And going back to what Jones was admonished for during the trial, Jones told the jury that he had complied with the court's discovery orders, which is absolutely false. Now, during discovery, plaintiffs asked for a number of different things, but they specifically asked Jones to identify the number of videos he produced about Sandy Hook. Jones and his co-defendants refused to produce this material, which is one of the reasons for the default judgment. And the plaintiffs' lawyers generally had a pretty easy time showing that Alex Jones was lying about the stuff that was actually produced.
Mr. Reynal had told the jury that there was 29 minutes total of InfoWars videos. He played 51 minutes in a single video, so we know that's not true. He has routinely, every single day of this trial, broken rules that a first-year lawyer knows. He has routinely placed inadmissible material in front of the jury. It is from our perspective at this table that Mr. Reynal is actively trying for a mistrial.
And the judge told Alex Jones's lawyer to stop many different times.
I am very upset that you have tried to imply to the jury that we know how many videos about Sandy Hook were released by your clients, when we don't, because they refused to respond to discovery. So I do not want you to do that again. And I don't want you to argue with me about it. That is the rule of this case. That's it. They didn't respond. We don't know. We've had multiple conversations about how I know you know what the rules are, and you know what the rules are, but you've chosen not to follow them on occasion.
And despite the judge's very clear instructions on the number of videos, Reynal interrupted the judge to argue.
The number of videos, their length, this is evidence that is being adduced in the courtroom.
Yes, but what you said was not, we've shown the jury 29 minutes of clips where the word Sandy Hook appears or anything like that. It was, they released in total 29 minutes. That is not true.
But the judge made it extraordinarily clear to Alex Jones what he could and could not do.
You may not say to this jury that you complied with discovery. That is not true. You may not say it again. You may not tell this jury that you are bankrupt. That is also not true. You're already under oath to tell the truth. You've already violated that oath twice today in just those 2 examples. It seems absurd to instruct you again that you must tell the truth while you testify, yet here I am. You must tell the truth while you testify. This is not your show. You need to slow down and not take what you see as opportunities to further the message you're wanting to further. And instead, only answer the specific and exact question you have been asked.
Now, what makes all of these exchanges particularly remarkable is that Jones's lawyer, Reynal, probably knew that there was a ticking time bomb that disproved Jones's claims about discovery. A ticking time bomb was that Jones's lawyer had accidentally sent 300 gigabytes of unredacted information directly to plaintiff's counsel, and that included Jones's entire cell phone backup. And sure enough, on cross-examination, plaintiff's lawyer Bankston reminded Jones that he claimed to have searched for messages related to Sandy Hook on his phone. Jones said yes, that he did the search, but found nothing.
So you did get my text messages, and it said you didn't. Nice trick.
And that led to the Perry Mason moment where Bankston absolutely skewered Jones on cross-examination by pointing out that these documents did exist in the form of text messages and emails that mentioned Sandy Hook. And the reason that Bankston knew that they existed is because Jones's lawyer accidentally sent him the entire cell phone.
I told you the truth. This is your Perry Mason moment.
Yeah, that's quite the exchange. And in fact, I have an entire video covering both this Perry Mason moment and the equally interesting hearing that was held the next day where the defense counsel moved for mistrial. And that also did not go well for Alex Jones. But since liability was already conceded, it didn't really take the jury very long to award damages to the plaintiffs. The jury found that Alex Jones should pay $4.1 million in compensatory damages for repeatedly claiming the school shooting was a hoax. Now, a court awards compensatory damages to put the plaintiff in the situation that they would have been had the harm not occurred. Now, compensatory damages include both economic and non-economic damages such as medical bills, lost wages, pain and suffering, mental impairment, and emotional distress. Heslin and Lewis were seeking $150 million from Jones, but the jury's verdict fell pretty far short of that mark. Jones's lawyer, Reynal, asked jurors to award a total of $8, $1 for each of the 8 harms the defendants inflicted on Heslin and Lewis. Of course, he couldn't ask for nothing because liability was conceded. Now, the jury's verdict was not unanimous. 2 of the jurors did not sign the form. In Texas, a civil jury verdict does not have to be unanimous. But that takes us to the punitive damages, or as Texas calls them, exemplary damages. Now, a court will award exemplary damages in Texas to punish the wrongdoer for their particularly bad behavior. Exemplary damages are also meant to deter people who might act like the defendant in the future. So in other words, Texas exemplary damages are meant to penalize the defendant for their behavior and to warn others not to do the same thing. And under section 41.003 of the Texas Code of Practice and Remedies, exemplary damages are awarded to a plaintiff if they prove with clear and convincing evidence that their harm resulted from fraud, malice, or gross negligence. But exemplary damages may only be awarded if the decision is unanimous. This, in combination with the clear and convincing evidence standard, makes it difficult to recover exemplary damages in personal injury cases in Texas. But there's another wrinkle, because in Texas, there's a statutory cap on punitive damages in personal injury cases. An award of exemplary damages may not exceed an amount equal to the greater of 2 times the economic damages plus an amount equal to any non-economic damages found by the jury not to exceed $750,000 or $200,000. And another subsection prohibits telling the jury about this particular cap. Now, the reason the juries are not instructed is that it might influence their thinking. They might shift punitive damages into the compensatory damages. So it's entirely possible that the jury can come up with a much bigger amount than the statute allows. And if a jury returns an award that is higher than the statutory cap, then the judge just simply reduces the amount. And in closing arguments, the plaintiff's attorney argued that this was the jury's ability to send a message to, quote, stop Alex Jones, stop the monetization of misinformation of lies. The defense argued that Jones had only spent 18 hours and 43 minutes talking about Sandy Hook and that they only made about $14,000 per hour during the coverage, and that should form the basis of the award. And following closing arguments, the jury returned a verdict of $45 million in punitive damages. But given the statutory limits that we just talked about, it's likely that the punitive damages award is likely to get chopped down to well less than $1 million. But that raises the question, what's next for Alex Jones? Well, the answer is more trials. On September 14th, the Posner and De La Rosa plaintiffs will face Jones in a Texas courtroom. In addition, Jones may find himself in deeper trouble with the January 6th committee, which wants to see all of the information that was on his cell phone, which was turned over to the plaintiff's attorneys. Jones took the Fifth Amendment 100 times during his testimony to the January 6th committee. And in this trial, Judge Gamble said she would not enter an order stopping Bankston, the plaintiff's attorney, from giving the material to the January 6th committee.
I mean, I don't know that you get to stop that anyway.
Additionally, Jones's lawyers are in hot water. Reynal is facing potential discipline by the Connecticut bar. On the same day that the Texas jury handed down the verdict, a judge ordered Reynal and Jones's lawyer Norm Pattis to attend a hearing about whether they should be referred to disciplinary authorities or sanctioned by the court directly for releasing confidential medical records in violation of state and federal law and contra the court's protective order. And although Jones told the jury that any verdict over $2 million will sink us, after the verdict, Jones's lawyer assured reporters that the verdict meant Jones would continue to be on the air, presumably profitably for the foreseeable future. Now, the other thing that could be next for Alex Jones is a perjury conviction. Many people have pointed out that it sure seems like Jones obviously lied on the stand, aka perjury. And to find out about the law of perjury and Jones's chances of conviction, you'll have to head over to today's sponsor, Nebula and CuriosityStream. On Nebula, my videos always come out early with 0 ads, and I release exclusive content all the time, like this entire video on the implications of Jones's testimony and whether it rises to perjury, as well as exclusive videos like things people misunderstand about the Constitution, why NFTs are bad for creators, and my first full-length documentary, Bad Law Words Good, and tons more, all exclusive to Nebula. And all of this exclusive content is available only on Nebula, which you can get for free with CuriosityStream. Nebula is creator-owned and creator-operated, and there's new exclusive content released multiple times every single day. Oh, and by the way, we've been developing Nebula like crazy. It now has apps for iOS, Android, Apple TV, Roku, Fire TV, and Android TV, and it was recently nominated for its first Streamy Award. My fellow creators and I really care about Nebula, and we're thrilled to be partnering with CuriosityStream because they are the go-to source for the best documentaries and long-form educational content on the internet. And they even have an entire section devoted to unsolved mysteries and crime. So if you like my videos, you will love the thousands of titles on CuriosityStream. Now, the best way to get access to Nebula and all of its incredible content is through the amazing CuriosityStream Nebula bundle deal with its current sales price of less than $15 per year to get access to both sites. And to be clear, that Nebula subscription is not a trial, it's free for as long as you are a CuriosityStream member. There just isn't a better deal in streaming where you get 2 great streaming sites with content that you'll actually watch and enjoy for less than $15 per year at its current sales price. But what's more is signing up will actually help countless independent educational creators beyond just LegalEagle. So sign up now by clicking on this button that's here on screen right now, or you can click on the link that's down below in the description. It's a great way to support educational content and get tons of exclusive content that you'll love. So click right now. And after you do that, click on this playlist over here for more LegalEagle videos. So click here, or I'll see you in court.